Hello and welcome back to Immigration and Jobs Talk Show with me, Dan Nandan. I'm the president of Hire IT People. Before we get started, this is going to be a completely open Q&A session. We had an overwhelming response last week. A lot of questions. We took about an hour to answer. Um, and once again, we have attorney Prashanthi Reddy. She has over 20 years of experience with the immigration law. If you need help, you can reach out to her offices at phone number 212-354-1010 or email her at prashanthi at readyesq.com. So this show is streaming live on LinkedIn, YouTube, and Facebook at Immigration Talk Show. If you, we have some trouble seeking comments from Facebook platforms. If you have a question, I suggest you log on to YouTube at Immigration Talk Show. That's one word, Immigration Talk Show. You can send your comments, or we are also streaming live on LinkedIn. You can send those comments. I will take them as questions and do our best to as the attorney. And before we jump into, we have one or two topics to cover, smaller versions, and then I will jump right into the Q&A. Welcome, Attorney Prashanthi. How you doing?
Hello, Dan. Good, thanks. How are you?
Okay, so I just wanted to get started with the, there's been a lot of buzz with the visa revalidation or visa stamping, which was active until I think 2004, where people would send their passports to Kentucky. And if I'm not mistaken, I don't know if it was in DC or Kentucky. Most likely it was Kentucky Consular Processing Center, where they would just send their passports for a revalidation. But we are hearing news about, as of January 2024, this whole process is going to come back. But it's a little it's a confused state of mind for a lot of our viewers here. Why is this limited to only 20,000 people? Is this based on their staff shortages, or they just want to run this as a pilot program? And this is something they have done in 2000 until 2004. So why would they want to run again as a pilot program? I'm talking about the US Department of State.
So let's just go back to the basics because a lot of people may not know what we're talking about. May not be good to presume what people know or they don't. So I always like to take a step back. Yes, as Dan just mentioned that earlier, there was a process called visa revalidation. And this visa revalidation is for people, used to be for people who already had a visa stamped in their passport and that visa was expiring and they need an extension. And right now, the situation is if your visa expires and you need an extension, you have to leave the country, go back to the consulate, and get a new visa stamped and come back in. To avoid that, USCIS came up with a program called visa revalidation some time ago, whereby this process could be done by remaining in the US. So we could basically what we would do is send out passports, original passports to Washington D.C. with a fee and a form. It was a very simple, easy process, and then we would get the stamped passports back, which we would then send to the client. So there was no need to go to the consulate outside the country to get those visas stamped in the passport. So AILA and other organizations have been trying to bring this program back for ages now. And every AILA conference, we hear from the Department of State that they're trying it out. They're trying to figure out how to do it because they've obviously dismantled the program that they used to have earlier and the department that they used to have earlier that did this, and they didn't want to burden existing departments with this additional process. But now I think they've realized that this has to be done because of the backlogs, still the continuous backlogs because of COVID. They haven't been able to catch up, and still processing time. It's so long, and just to get an interview itself, the time period to get an interview itself is so long that they are having to come up with programs such as this. So I guess they've made an announcement that they will introduce it. They're introducing it. They will publish regs for this next month, that is in December. And sometime in January, they plan to start slowly as a pilot program so that they can see what the issues are, if any, in this program and make changes or modifications as needed. So they will select 20,000 applications to start off with, visa applications. They haven't yet said how they'll select the 20,000, whether it'll be a lottery.
But
Most probably
again,
it won't be first come, first serve. Most probably a lottery, another lottery. What fun. But I think it's a start of something good. If this works, then this will help a lot of people who are now stuck without being able to go back or travel or go back to their home country because the visa wait period is so long, they're not able to go back right now. And for the holidays as well, nobody can travel. So I think this is great. And also, it will reduce the backlog, as I said, on the existing visa interviews because there's so much of a backlog on those for the ones that are needed. Also, Dan, you have to keep in mind that this visa waiver program, meaning the visa interview waiver program, is expiring in December. So that will again put a burden on the consulates and that link to conduct interviews for every single person, even for extensions.
you mean the
Um,
Dropbox?
yes, the Dropbox program.
Okay.
So I think on another front, I think there are a lot of organizations and companies trying, including AILA, trying to extend that visa waiver, interview waiver program as well, the Dropbox program. And I think both might happen. The USCIS and the Department of State, which has to work together on this program, have indicated that they intend to, but let's see what happens with both the visa revalidation as well as the visa interview waiver program.
Now, one thing I wanted to ask here, when they shut this down, this whole visa revalidation in 2004, the very reason was for the inability to collect the biometrics. Now, if somebody is going to mail it to the DC office, now what happens to the biometrics?
I don't see why they cannot collect biometrics. They do that in green card applications, which is sent by the mail. It's the same thing. They can collect biometrics. They can send in, the biometrics form that like they do now, appointment form, and they already have centers where, biometrics are collected, photographs are collected,
So these
fingerprints are collected, so that can be done.
so they're going to work in conjunction with the USCIS field offices to
Yes,
the
that's why
biometrics.
I was saying that they have to both for the visa interview waiver program as well as this revalidation program, they have to work in conjunction, I think, with the USCIS, unless they plan to open up their own centers for biometrics collection, which doesn't make sense.
So it's only like we are close to December. They said January of 2024. So we have to, when we have more updates, we will definitely bring up another topic on a show and provide more information on the process. Once uh, Attorney Prashanthi has more data on this, we'll try to bring up on an entire show just to cover how you can revalidate your visas. For now, we know it was talking about H1Bs. We're not sure about other visas at the moment. If attorney has any other info, but I think we should, since we don't have much data at the moment, I think we should move on with our open Ask Me Anything session. Thank you for that information on the revalidation. Welcome back. We have a question from on YouTube from Tej. There's a gap in H4 EADs. Old EAD ended 4 days prior to my old I-797, and the new EAD start date aligns with my new I-797. Will USCIS fix this, or do I have to file additional standalone EAD? Please advise. It looks like I think I was chatting with this person yesterday, Looks like the extension of the EAD was filed in time, but I'm not sure if he or she qualifies for the automatic extension, because before the expiry of the current EAD, they filed the extension, and the new EAD came in with a gap of 4 days. So that's what he or she is worried about. Now, what happens to these 4 days of, if they were employed, he or she is employed. Now, what happens to these 4 days are nothing to worry about. This petition qualifies for automatic extension. Can you please clarify on these items?
So whenever your EAD is expiring, or the date that it expires, you have to stop working. And once the new EAD comes in, you have to start working from the date that that new EAD comes in. So there's no question of a gap because you have to follow that process. Stop working as of the date that your EAD expires. Start working as of the date that your EAD gets approved. So Dan, is that clear?
Yes.
So there is no question of a gap. We have to kind of make sure that our employment coincides with the dates on the EAD.
So now what happens? I think even I'm not clear about Tej. If you can clarify on I-797. Are you referring to the I-797 of the principal H1B, or the I-797 on the H4 EAD receipt notice or the approval notice? So if you can send another message.
And even if it's the I-797 H4 approval, that has nothing to do with work. Just to clarify, that has nothing to do with the EAD. The EAD has its own validity period, so we have to follow that validity period uh, when we're uh, deciding on employment.
Okay. Tej, I hope your question is answered, but if it's not clear, you can certainly come back with another question. In the meantime, I will try to jump into the next question here. Um, all right, welcome back. We're back to the 60-day grace period session. We have more questions here from people. I think there are more layoffs from Pawan. I'm in a 60-day grace period and in a previous company H1B visa. Shall I stay with previous H1B visa?
So if you're already on a H1B, how does the 60-day grace period come in? It's only if you get laid off that the 60-day grace period comes into place. So I think you need to clarify your question.
I'm assuming, because we've had similar questions last time. I think they're talking about they took the 60-day grace period, but then unable to find a new employer. So if the existing where they left off, if that H1B is still valid, maybe the other employer is wanting them to come back.
Well, if they've changed their minds and if they're wanting them to come back, then um, you have to, a couple of things that you have to make sure. First thing is, I'm presuming that the employer never withdrew the H1B, which they're required to if they've laid you off. If they have not withdrawn the H1B and if your H1B is still valid, then I don't see why you cannot go back to your employer within the 60 days period, even though you are not on the payroll, you are not out of status. And I don't think any further action needs to be done on your H1B as long as there was no withdrawal, as long as it was not withdrawn. So you should be fine.
Okay, thank you for answering that question. We'll jump into the next question here. Before we get there, to get more immigration updates, you could simply subscribe Okay, it's stage again. Yes, the I-797 on the principal. So the H4 EAD that you were trying to answer.
Right. So the I-797 of the principal, again, usually that's a different issue as to whether your H4 has been maintained or not. It's not a H4 EAD issue. You have to make sure, of course, that there is no gap in your H4 status itself. And even if there is, I think it's not a big deal because when you file your green card, there is an automatic um, kind of, instance in which they will forgive the less than 6 months out of status period, 245K under the regulation. So that 6 days should be covered in that. So I wouldn't worry too much about the 6 days, even if your H4 has not been maintained. And with reference to EAD, we have already responded that the job has to go as per the EAD, not the other way around.
Okay. Thank you. And there's a thanks from Tej as well. Thanks for joining our session. If you have more questions, we are here. This is an open QA session, so please post your questions. We will ask comments. There is no, way to call here, but then we will definitely take all those comments. I have the stream coming in from right now from LinkedIn and YouTube. If you're watching on Facebook, you have trouble. If you were trying to send a message and I'm not reading this, so that means there's a problem. So you could simply go to youtube.com at Immigration Talk Show and post your comments. I am gathering all those questions via comments at this moment from LinkedIn and YouTube. Thanks for answering that question, Prashanthi. Our next question is from Unisa Banu. Can a person file for EB1A and I-140 and I-765 together? My question is specifically if you are a citizen of India and your birth country is also India.
Uh, if the priority date is available, you can, and priority dates keep changing. Priority date for EB1 is presently not current if you're an Indian national. Therefore, you cannot file. You can file the I-140, but you cannot file the 485. And unless you can file the 485, you cannot file a 765, which is the EAD, which accompanies the 485. So the question is, the answer is no. You can't file I-765 and I-140 together if you're an Indian national and you were born in India.
Okay, so only when they actually file the 485, so they just file the I-140, obtain an
Correct. They file the I-140 under EB1 and then wait for it to become current. Once it's current, they file then the 485, 765 advance parole. They can file everything together. EB1 was current for a long time, but has recently become backlogged for Indian nationals, unfortunately, and we are not expecting it to become current anytime soon. So that's the reality of it.
So now, they can also use the, since this, if they're doing a self petition on the EB1A, can they use this approved 140 if they're on an H1 or, maybe L1? Can they use this to extend beyond the 6 years?
Yes, they can. Doesn't matter what kind of I-140 is it is, and you can also transfer the priority date between EB2 and EB3. Uh, so you have that flexibility, but still that doesn't help because all EB1, uh, no matter what basis it's on, falls under EB1, whether it be based on L1, multinational executive or extraordinary ability, national interest waiver, whatever it might be, it's still under EB1 and the dates are not current for it.
So, in her case, if she already had an EB2 or EB3, let's say from 2018 or 19, when she files for the EB1A, can she still use the priority date from
Yes,
other?
yes, she can, and that might help her situation if that's the case. Because the priority dates, I don't remember what it is for EB1, Dan. I don't know if you remember, but it might most probably be current if you use the your EB2 or EB3 priority dates. I think it's 2019. I don't
Right,
recall.
2019.
Yeah, so
They
it's a
were
good
current until
chance.
last year, so everything
Yeah,
changed overnight.
Right, right, correct. Every month it changes.
Yeah, unless there is some kind of new legislation where they're going to add more. With the 7%, we don't even know if this is going to happen. In the at least but I wish good luck. If you are waiting in the green card line, we'll definitely bring some updates if there are any congressional changes, any approvals. It's going to be in the news, but we'll definitely try to um, uh, have another conversation with Attorney Prashanthi and try to understand more on the nitty gritties. And if that comes up, what could be the process. Thanks for answering that question. And Unisa, thank you for your comment. If you have more questions, please keep commenting, and we will keep taking your questions and answering. Thanks a lot from Unisa. It was really informative. Thank you. Good luck. Let's take the next question here from Facebook. I think we are rendering Facebook comments now. If we applied H1, H4, and H4 EAD at the same time, H1 and H4 EAD approved, but still my H4 is showing as case received. If my H1, H4 didn't approve before existing EAD expired, am I eligible to work with new EAD without H4 approved? It's strange. Um,
Yeah, I mean, it happens sometimes with USCIS. Nothing is strange. They don't. um, but generally, yes, the H1 and H4 and H4 EAD, as we know, if you apply it at the same time, everything gets processed at the same time. So I'm quite kind of surprised that H4 is not processed. But then again, it may be processed, but maybe the online status has not been updated. That might be the most likely explanation for this, because they don't always update online statuses. So you might be seeing it as case received, but you might be surprised and you might actually get an approval in the mail. So let's wait and see. I think that might be the case. But you can't work obviously unless you have an EAD which is valid. So you have to wait and see what happens. See if it comes in the mail. Usually, once you get the notice, it takes about 10 business days to get the notices in the mail.
okay. Thanks for answering. I hope your question is answered. We'll jump into the next question here. Okay. I think there are follow-up questions here from, but let me jump into a little something here. Okay, I think it's a Facebook user. He said thank you. He or she already received the EAD card. Um, okay, that's good. Um, Michael, what are the possibilities to get a green card on an H1B research visa with an Indian passport? So, Indian passport, or Michael, is it Indian passport or Indian born? So, there's a big difference between having a nationality. You might be born in, let's say, some Saudi Arabia or United Arab Emirates. So, you go on country of birth. But then, attorney would, Prashanti, if you can just, deem it as, Michael is born in India, and answer this question, please.
When the person says Michael is saying H1B research visa, does that mean he's working for a cap exempt research organization? Is that what he means? It's not clear.
That's a possibility.
But let's presume that he is working in the research field. It's possible then that if he's working as a researcher, you can apply for a EB1 researcher category, and that's relatively easier to get when compared to exceptional ability category. It's both are EB1, and so on that basis, you can file an I-140. There's no perm that has to be filed, meaning there's no labor sub that has to be filed. You file directly an I-140. But again, once the I-140 is approved, you have to wait for EB-1 to become current, and then you can go ahead and file the 485. So there's, yes, absolutely, there is a possibility of getting a green card for any employment-based category, but you're in a better situation because you might be EB-1 if you are in the research category.
Okay, thanks for answering that question. We'll jump into the next question here. Okay, there's a question from JBR Prasad on YouTube. Hi, sir. Can you please brief me about the process status transfer from H4 to H1B? Like if there's any premium processing available, or we need to go with the lottery system. It looks like, I think he's on H4 and trying to get into the H1B registration process.
So if you've never been on a H1 before, you have to apply in March. You'd have to register. Your employer will have to register for you. And it's a lottery system that they follow. So once you register, based on your passport number, hopefully they'll do it this way uh, the next year. But most probably based on the passport number, they will accept your registration and they will do the lottery. And if you get picked, then you can file for a change of status from a H4 to a H1. Premium processing is available for cap cases, but they keep changing it every year. So they make the announcement in the beginning of a cap season whether they will premium process these cases or not. So we have to wait and see.
Okay, so when the H1B season comes in, if you have an employer and if they're looking out for an attorney service, Prashanthi comes with, she's patiently answering these questions. And she comes with 20 plus years of experience with immigration law, practicing nationwide, supporting both employers and people like you. She can be reached at phone number area code 212-354-1010, and her email is Prashanthi. Someone asked me the spelling last time. It's a H-I Prashanthi at ready, REDDYESQ.com, or you can visit them to fill a form, so to get a consultation and get your season lottery H1Bs filed with the upcoming season, readyesq.com. Thanks, Prashanthi, for answering that question. Let's jump into the next question here. Um, oh, this is, a lot of people, it's a simple question to you, but then is there any chance for visa, Manjula Devi? Is there any chance for visa appointment in Canada instead of India?
Yes, there is. You can shop for the consulate that you want to go to. You can absolutely go. Of course, you have to make sure that you have uh, sufficient means and a place to stay in Canada if you go there, because it's not like you'll get the visa the next day. There is a processing period for the visa. They have to do security check, background check, etc., etc. Sometimes when you go to the consulate outside of your own home country, they might deny the visa or refuse to look at the visa application because maybe your application requires the Department of State to look at something at your home country. It could either be because you have an Indian degree and they want to verify it, or it could be that you are doing an L1 and the office, the parent or the foreign branch is in India and they want to verify whether that exists or not. So usually they will accept it and you can go to Canada, but sometimes they might deny your visa on these grounds and ask you to go back to your home country.
So, and what about the requirements to enter Canada? Is that something we can touch? If somebody's on an H1 without a visa, they just have an H1B,
Right,
and
that is Canadian immigration, but yeah, that's pretty common
you need a
knowledge.
visa to go to Canada,
Yeah,
right?
yeah. You don't need a visa to go to Canada if you're on a H1. You can enter. Canada as well as Mexico without visa, so you don't need a visa. But if you, in order to come back into the US, this is another important question. In order to come back into the US, if your visa is denied and you're going for the sole purposes of getting a visa, they may not allow you back into the country without a visa. So that's something to keep in mind. But if you're going as a tourist, to go to Niagara Falls or something like that, or you're going to Cancun, you can come back without a visa, even if you don't have a H1B visa stamped in your passport. You can just show your I-797. But if you're going for visa purposes, again, and your visa gets denied, then you may not be allowed back into the country. So there's a distinction here.
So that's the I-94 automatic revalidation. That's what you're talking about.
Correct. Yes, yes. They may not allow you back on the I-94. They may ask you to, show a H-1B visa at the port of entry.
I do see a lot of these questions about people who want to go on a vacation to these Caribbean near shore countries like as you said Cancun, Mexico, or maybe Niagara Falls, Canada. Do they often get into trouble while returning to the US without a valid visa stamp on their passport?
No, I don't see that happening unless there's some circumstances which get them into trouble. In general, I don't see an issue with traveling for pleasure on your H1.
Okay. Thank you for answering the question. We'll jump into the next question right in after this small break. All right, welcome back. I see a lot of questions now. Sati, this is about an H1B extension, from commenting from YouTube. I filed my H1B visa extension and my visa got expired on the 30th September. I'm in a 230-day grace period. I think it's 240 days, right? Could anyone confirm if I resign my job, how long can I stay in the USA searching for a job?
Again, that's a 60 days grace period. The same thing will apply to you, so you can. So it doesn't have to be. A lot of people have this. If you are laid off from your job by your
Prashanthi,
employer,
your camera
but it
flipped.
also applies if
Prashanthi, I'm so sorry. Excuse
you
me.
have decided to leave the job on your own accord.
Prashanthi, excuse me.
So,
Your camera flipped.
hello, Dan.
Yeah, your camera flipped.
I'm
Hello?
sorry.
Looks
Are you
like,
okay?
yeah, it looks like your camera flipped.
Nothing has changed on my end.
Now, can you make it in a portrait, maybe? We see a inverted camera
Sorry,
now.
guys.
No problem.
Is this better?
Yes. Okay.
Yeah, I think it flipped on
That's
its own accord. Something happened because I didn't do anything. Okay, this is technology for
yeah.
you.
When we have so many problems with visa
And your
bulletins and
volume is,
layoffs.
I have lost the volume. It seems like you're not on a
Hello.
speaker anymore.
Hello.
I
Hello.
can't hear you. You're not on the speaker mode for some reason.
Can you hear me now? Uh, this is a test. Hello, can you hear me now?
No, I still can't hear you. Very faint.
Can you hear me now?
No. Should I leave and come back?
Sure. I'm not going to
Let me
end the
leave
stream.
and rejoin again. Sorry, folks. We'll be back in a minute.
Yeah. Welcome back. Can you hear
Oh,
me?
there you go. Yes, I can.
Okay. All right. So we'll just get right back to the question once again. Sorry, Sati, we had some technical trouble. I have filed my H1B visa extension, and the visa got expired on the September 30th. So it's been like September, October, and this is November, so almost 3 days. And he or she is still in the 230-day grace period, 240-day extension, whatever. And please confirm, if I resign my job now, how long can I stay in USA? So not resigned yet. So the 60-day grace period still applies.
Yes. Are you seeing? I don't see my video, so I don't know.
You can see your video. We can see
No,
you.
I can only see you. I can't see myself.
You can see now.
No. Yeah, now I can see.
Okay.
Okay. Okay. So I think we were discussing this previously. So just to go back to what we were discussing.
Sorry, folks. I think we have a little trouble, technical trouble today. We'll try to fix this right up. Welcome back. Can you hear me? Hello.
1 second. 1 second.
Welcome back. Can you hear me, Prashanti?
I can.
Okay.
Sorry, I need to just reset.
Yeah, no problem. Okay. Next
Sorry
question.
about the
No.
interruption.
Yeah, as we said last time, there were a lot of layoffs, and a lot of techie workers, you know, not here to. I see. Even if I went to Chase Bank. It's so funny though. I sent out a wire on Friday. It takes an hour, and today is Wednesday. Everything looks fine. They said they're still in process. A wire for 3 days. Um, you know, understaffed. So let's
Right.
jump right into the next question here. Sorry, folks, we had some technical issues here, but we will continue taking those questions. Please throw in those comments as your questions. Now, the next one here is from Dilip. How many days can we work on an H1B extension receipt notice?
I think the previous person answered that question, right? 240 days, and then you have to stop working, but you are not out of status. So, yeah, 240 days. Then you stop working, but you can still remain in the country until your H1 extension gets approved. So, you don't have to leave the country, but you'll have to stop working.
Okay. 240 days. So keep that in mind if but there's always an option to upgrade to premium processing. If we remember correctly, there were days when there was no premium processing, there was no choice. But then, it makes sense to send out if you can explain, how they can upgrade to premium processing, and if they can send their own check instead of the employer.
Yes, yeah, so that's definitely a thing to do if you're filing if your company has filed an extension, and you haven't heard anything yet. There's no reason not to do premium processing. A lot of people have think that doing premium processing is a bad thing and that there's more scrutiny, etc., etc. It's not like that. It's just that there is, uh, I visited the Vermont Service Center many years ago, and they were talking about premium processing, and they said that they have only their most experienced officers who are sitting at the premium processing section. So,
So,
and they're
so
well
that means
trained.
more scrutiny, right? If there's more experience, there's more
Well,
trouble.
no, they will sometimes when people don't know what they're doing, they might ask questions which are not relevant, right? So these people, I've never seen any issue with premium processing. Really, I've not seen more RFEs or less RFEs. It's just they're doing their job, I think. Of course, you could say that because they don't want to process in premium, they're sending out more RFEs so that they can, take the money and not process in premium. But it doesn't usually happen that way. In fact, maybe there have been one or two instances where I've seen that happen in so many years. So I think it's false kind of rumor that is around. But anyway, so you can file for premium processing, and all you have to do is send in the premium processing form I-907 in order to do that, and then you send in the check. The attorney, the employer or the attorney has to do that, but the check has to sign the I-907 form. So the employee cannot sign that form, and it cannot be done without the permission of the employer, obviously. But the check can be sent in by the employee, so that's not a problem. But the form has to be filled out by the attorney or the employer and signed by them.
So it can be either a check or a cashier's check, bank check, or a money order,
A
or
money order, correct, yes.
that's easier, right? Because if they
Yes.
make a mistake on the check, yeah, that might delay the process. Okay, thanks for answering that question. Let's jump right into the next question here. Please keep posting those comments as your questions as comments, and we are taking all these as much as we can. We still have some more time here. I will definitely take as many questions as we can today, as this is an open Ask Me Anything session, AMA. Okay, the next question here is from Divya. Um, I'm on my F1 visa. Currently, I'm pursuing a master's degree. I need to apply for a new H1B work permit upcoming year. Can you please explain me the process? Can you do that in a nutshell? I know it's a long process, but if you can, since she asked the question, we've been talking about taking the questions and answering them. So I'd love
Right.
to get this answered.
Yes. So if you are presently on some other status like an F1 or a H4, and you have never applied for a H1 before, you've never received a H1B approval before, then you are subject to the H1B cap. And if you are subject to the cap, then what you need to do is, as a first step, you need to register when the registration process opens up, which is usually in March. Around March 15th or March 20th is when the registration process usually opens up. During that time, your employer will have to register. It's a very simple process, that you fill out some basic information. You need your passport copy, and you need to submit a basic form which has your passport number, name, employer information, and then it's been at a $10 fee for now. So we don't know if they're going to increase that fee, but as of now, it's a $10 fee that has to be paid for that process. So, and also it's important to understand that your employer should not file multiple registrations for you. They should only file one registration. Recently, we got a notice of intent to deny on a case where the employer did their registrations themselves, and by mistake, they registered for the same person twice. And while the system has become very clever now, that and the system will actually catch it. But in this case, the name was entered in a different order: first name, last name, middle name. So the system didn't catch it, and they registered twice for this person, and the registration got picked, and we sent out the H1, and then they sent out a notice of intent to deny, because there were two registrations for the same person. Even though it was something that was unintentional, still the H1 could not be approved, and we had to withdraw it. So make sure your employer doesn't register twice for you. You as a beneficiary can register yourself with more than one employer. But if the new system kicks into place, you will still get only one pick at the Apple, because they will only look at your passport number, and based on the passport number, they will register. So even if you register 10 times to 10 different employers, you will only get one pick in the visa lottery system. Hopefully that will be done this year. Otherwise, there was a lot of confusion last year when this was not done. But let's see. Let's wait and see. As of now, you can register multiple times, and you will get multiple picks, chances based on each registration that you do. But let's see what happens moving forward.
So in the new
Once
system, sorry, go
once
ahead.
you register, then the result will come in by April, and then you will have 90 days to, if you get picked in that lottery, then you will have 90 days to process. Your employer will have 90 days to process your H1, and if it's not processed within that time, then you will lose that registration. Unfortunately, you will not be able to. You'll have to go through the entire process again next year.
Okay, so if assuming that the new H1B modernization program kicks in, so they will have only one unique registration irrespective of the number of jobs. So I was also reading the article, the publication. Now, if let's say, because it's only one person, every employer can petition. Now, what happens if multiple employers have still petitioned? Now there are 20, in 2023, based on the publication data, one person was filed 83 times. This is official data. Now, what happens if, how is this going to change if, there is one single beneficiary, but then they're going to invite, multiple employers to still file the H1? Wouldn't that be chaotic once again? How would that stop the problem?
So, based on this, the new proposed regulation NPRM, published in October, it's only proposed, remember, so there's a 60 days comment period, and then after that they'll decide. But with one of the proposed regulation changes was that, with reference to registrations. So this particular aspect of NPRM, they might accelerate it. We don't know. Maybe they will publish a temporary regulation, which they are able to do without, going through the entire 60 days comment period, etc. But what they propose to do in the NPRM is that they will identify the registrations based on the passport number. So if one person registers 75 times like they did last time, they will only get one pick because they only have one passport number. So they will look at the unique and that's a unique identifiable number. So they will pick the lottery based on that number. So they will only get one pick like everybody else. And then once the registration, if it gets picked, then they can decide which H1B they want to file, or they can file for three H1Bs or five H1Bs also. But obviously, they cannot work. So this doesn't affect the registration process, doesn't affect the number of H1Bs, that can be filed under the registration, which is 85,000, right? So that doesn't affect that. So you can file multiple H1s, but it doesn't affect the number. So that's a good thing. So they can file, but of course, at the end of it, they can only have one H1B approval because can't work for multiple people unless they're filing concurrent. So they have to decide which H1B they want to keep. And and then we have to remember the last action rule, whatever H1 they file last will ultimately become their status even if they don't want it to, unless they withdraw that H1 before it actually gets approved. So there are all these issues to keep in mind. So it's better to stick, unless you think that there is some reason that you don't trust that employer that you're filing the H1 with, or you think that it might get denied, then you can, file another H1 as a backup, but you have to decide which one you want to keep before it gets approved to avoid
So,
confusion.
I do have a question here. Let's say three employers are filed, and all the three H1Bs are approved before the start date of October 1st. Now, how does the last action rule apply? And or uh, the beneficiary has a choice to choose between any of these three employers?
So the last action rule applies based on which petition they filed last. So if they filed a particular petition last, then that will become their H1B status. Um, but again, we could argue, and another thing to look into it is last action rule may not look as simple as it does in other cases, because these are cap cases. So you can argue that the petition doesn't start as of until October 1st. So maybe the last action rule won't even apply here in this situation because
Okay.
everything is starting on October 1st. So everything starts at that time. So it'll be interesting to see how they will look at these kind of cases, because last action rule may not apply because everything starts on October 1st. So something to keep in mind and look into. So I would say, in order to avoid all this confusion, withdraw the H1B before it gets approved. Don't file premium processing, so it give you time to withdraw it. Once you get the H1B that you want approved, withdraw the other H1B petitions. But again, you have to remember this is not in your hands because the employer is filing the petition and only they can withdraw it. So you're really causing a lot of confusion for yourself if you are the beneficiary, if you're applying for more than one H1B petition at a time.
Okay, Divya, I hope your question is answered in somewhat details. I know this is a very long topic. She
Right.
needs probably hours to go through the entire process. But then,
I think
if
we
you
answered more than her question. We had a whole discussion around it. Yeah,
so
I think it'll be
when
useful.
the time comes, if you need an attorney service, Prashanthi can be reached at 212-354-1010. ReadyESQ.com. You could just log on to their website, and if you have an employer, you can always request the employer to connect with her to seek her professional services. Now, let's jump into the next question here. We still have a lot of questions floating. Welcome back. My next question here is from YouTube. Shritin, since you posted a question, uh, this is out of topic, but I would still pose this here. It's a general answer that we can all, as immigrants, we can all, give you an answer here. A good company start with to get a smooth processing. Maybe ich spreche eine kleine Deutsch. If you speak German, maybe yes. Maybe for IT, there are many opportunities in Germany, but many countries now, it could be. But definitely, I think I will let Prashanthi answer this about the delay or extreme delays in getting a green card. But then personally, I would love, I've traveled all over Europe. I love USA. It's a beautiful country. No headaches. You can do what you want, unless don't end up in fights with people. But you might be out of place. Unless you are a fluent German speaker. That's what I've noticed when I went to these countries in the European Union. But Prashant, do you have anything to add to this? As a little change of the regular immigration.
Well, is Germany a good country to start with to get a smooth processing? Well, smooth processing of what? Of
Listen,
your
you're
life,
probably
your
no, no. You're
career,
probably looking
your
at the
immigration,
H1B, somebody going to
US immigration?
the. I'm
Smooth
assuming he's
processing of
asking for.
what?
If the question is about H1B visa, that you are applying at a consulate
Right.
in Germany, I think
Yeah.
she's been answering about Canada, and the answer would be the
So it's
same.
the same process. If you're, if you're living in Germany and you're not born in Germany, and you're born in India, whether you live in Germany or Antarctica or wherever you live, it's the same process. You have to go through the same green card waiting line because you're an Indian national. Your ability to get a H1 visa is to the same to the extent of the registration because it's a lottery for everyone, no matter which country you come from. It might be easier to get a date for a H1B visa once the H1B is approved. Maybe the backlog is not as bad in Germany as it is in India, so getting a date will be easier. And perhaps the scrutiny will be a little less at U.S. consulate in Germany when compared to Chennai or Hyderabad. So those are some of the advantages, but not that many really.
Okay, thank you. We have a green card question here from Shirisha Reddy. Can a green card lottery recipient apply for U.S. citizenship in 3 years without marrying a U.S. citizen? Is it possible to skip the standard 5-year wait period rule?
A
Right.
green card lottery recipient. I don't remember this with reference to the
EB
GC
lottery.
lottery process. I don't know if it's 3 years. I know that only for if you're married to a U.S. citizen, then you are allowed to file your naturalization within 3 years, and you don't have to wait for 5 years. For the lottery, I don't remember. Sorry, whether it's 3 years or 5 years.
But then,
For everybody else, I think it's 5 years, but I don't remember.
as far as I read, yes, you're right. Now, when they come on this, DV lottery, do they also get like a conditional green card, like when they marry a U.S. citizen? It's a conditional green card for 2 years or 4 years, right? Is the
Again, I don't recall because I haven't looked at that. Don't do much of it, and I haven't looked at it for a while. We can
Okay,
certainly look it up and then give them an answer later on.
sure. Thank you.
And I don't want to guess. I don't want to say something out of memory.
All right, let's jump into our next question. I do see all your comments. I'm taking one after another. I'll do my best to pick up as many questions as possible today. This is from Ali about a TN visa chatting from YouTube. Have a TN visa, but the officer mentioned they stopped doing stamping and suggested to get the I-94 from online, I-94 form online. Is that the only print required to enter the US, or I need to fill any form or need a stamp? So he
Yes,
got.
that's yeah. It's been a while actually since they've stopped for all visa statuses, whichever visa you're coming in on. Um, it's been a while since they stopped stamping the I-94 in the passport. Now what they do is, or giving a white card. Sometimes they stamp, sometimes they don't, but they've stopped giving that white card, which is the I-94 card. So what they're expecting is that you can come into the country because you have a visa. You've already You already go through, CBP to do that, and they allow you in. Once you're in the country, then you'd have to go to the website, the I-94 website, put in your passport number, and then you'll be able to print out on a white piece of paper your I-94 approval, and that will give you the date until which you can stay, and you can either print it out, or if someone needs to look at it as proof of status, that's what you need to do. So that's the only thing required. There's no white I-94 card, and sometimes they don't stamp, sometimes they do stamp, depending on where you're entering, which airport or port of entry you're entering at. And the stamp is anyway not proof of status. What is proof of status is that I-94 of that is that you have online.
So, how do they obtain a copy of the I-94 online?
Well, you have to go to the website. Just type in I-94 website on Google, and you will get to that website. And then type in your passport number once you get the website, and it will give you your entire travel history. Is one page, and the other page, it will show you your I-94, your present I-94, and its validity. So you can just print that out, and that will be your proof of status.
Okay. So, what if they tried and nothing comes up? What happens? Should they go back?
Well, usually it does. It's unusual when it's not, because they enter all that information into that website. But if it doesn't, then you can contact CBP, your local CBP, wherever you entered into the US. There are numbers again online. If you type in CBP and that particular port that you entered from, such as LA CBP, etc., New York CBP, and there'll be a phone number available. You can call them. You can go in person if they allow you to come in person once you've called them, and they should be able to fix that problem for you.
All right. Thanks for answering that question. Let me jump into the next question here. This is from Shiva. I think this is about the LCA. I think we've had now. Shiva, if you look at our videos on at Immigration Talk Show, we definitely touched this topic. But then, since you raised this question today, does the location affect on H1B even in the case of work from home?
I'm glad you interpreted what WFH means. but
No. Okay.
uh, but thank you. But so yeah, um, does it affect if you're working from home? Yeah. So location. Do you mean the end client location? What do you mean by location? So basically, let me just answer that broadly. If whenever you file an LCA, before you file the H1B, you have to put in the work location. Based on the work location, your prevailing wage is determined, and that prevailing wage has to be put onto the LCA, and your employer is obligated to pay you that amount of money, that prevailing wage. So yes, work location is very, very important. Whether it be, doesn't matter whether it's work from home, or you're working from the client side, or you're working from your employer's office. Work location is important, and your how you file your H1B and your prevailing wage is determined by really your work location, whether it be work from home or it be employer location or client location.
Okay. So I have a follow-up question here. So, do they require the amendment of the LCA or the H1B if the client location was not in the same metropolitan statistical area? And if you can touch that a little bit. So, I'm
So
assuming
that
that.
really, then that is really depends on whether the client location was the work location. See, I said work location is the key. So if the client location was the work location, then yes. And if that location changes, then obviously you have to file an amendment. If it is outside the MSA, outside in a different county or a different state, so then you definitely have to file an amendment in that situation. If your work location is, say, your home, and your client location has changed, then you don't have to file an amendment because you're not working from the client location anyway.
Okay. Thanks for answering that question. All right, welcome back. Sai Nikita, with an approved EB to I-140 and a new industry H1B. I'm not sure what is new industry H1B. Can I renew my H1B beyond 6 years until obtaining a green card, considering the EB1A denial and recent approval in May 2023? So she has an EB2 I-140 approved. And I think the question is straightforward in terms of extending the H1B beyond 6 years using the EB to 140. But I think she's trying to relate it to the EB1A denial, and which is again approved maybe in May 2023. So can she still use any one of these approved I-140s to extend beyond 6 years?
Yes, she can, because you just need one valid I-140. Again, even if the I-140 is withdrawn, as long as it's not denied or withdrawn by USCIS for fraud, you can still use that I-140 to extend your H1 beyond 6 years, and it doesn't matter that one of the EB1 didn't get approved, one of the I-140s didn't get approved, because you have the other I-140 which is already approved.
So it doesn't really matter it's from which employer, they're filing an H1B with employer Z, but they had it from employer A. There's a long gap of employers. They changed employers. It doesn't really matter, it can be a mix and match.
Correct, yes.
Okay. Sai Nikita, I hope your question is answered. We'll jump into the next question here from Milan Patel. Is an H1B approval possible for a hotel operations manager, hospitality industry?
Right. So we used to do this, these H1s. Uh, I don't know. I used to do them at least 15 years ago, 10 years ago, when USCIS was a little bit more liberal with their granting of H1B approvals. And even then, it was difficult to do, and not every case would get approved. So I think it really depends with reference to a hotel operations manager or a chef or you know people who are working in the hospitality um, area who have a degree in hospitality management or hotel management. I would say hotel management. Um, it depends on the size of the restaurant or the hotel. Um, so for a huge hotel, which really operates like a business, like a five-star hotel, where there, hundreds of people working, it will be easier to file H1 for an executive chef position or a hotel manager position or a restaurant manager position. So it depends really on the size of the hotel. So and it's not possible to answer that. It really depends on how big the hotel is. If it's a larger hotel, it's possible to get a H1 approval. I would say if you have no other option, to try, as long as your H1 or your status is not expiring and your status is safeguarded. The worst that can happen is the H1 will get denied, and you will continue to maintain the status that you're in. So I would definitely say try, um, if you don't have any other option or any other uh, job is there's no other job that's offered to you, or you can't do better with reference to job title.
Okay, Bilan, I hope your question is answered, but I hope you definitely get an H1B visa. We started this during lunchtime. We're pretty hungry. But then if you come in, give us a call. You can see my email right on top. Send us an email and bring us in for lunch at one of your restaurants. Thank you. I'll
Thank you.
jump into the next question here. Muhammad Ashik. I need some advice. One of my friend had an H1B interview today. So they took their passport but still gave her a 221G paper. What does that mean?
Um, yeah, the ways of the consulate. Who can understand the ways of the consulate, or how they act, or why they act in a certain way? But yes, generally, if um, a visa is being denied, they just give them their passport back, and then they give them a 221G, and then if the administrative processing gets approved, then they will call them back and stamp their passport. But it could be that they are holding it to check something, or maybe cancel something in the passport, or maybe they just haven't gotten to giving it back to you. Maybe they will send it in the mail or call you back. But so I can't really say why they're holding your passport. Could be various reasons.
So it could be that they were almost on the brink of approving the visa, but they still have, there's a benefit of doubt that they probably want to check the credentials, or the availability of job. These could be, there could be multiple reasons. But then but have personally, I have not heard about they give away the passport and they still hand out the white slip, or whatever, the pink or green slip. But have you heard anything like this before?
Yeah, US, I mean, I shouldn't say USCIS, Department of State and USCIS and all these organizations involved with immigration do a lot of things that are not explainable. So I'm never surprised at anything that comes my way because it's quite possible. We've always heard of it before.
All right, thank you for answering that question. We have another 15 more minutes. If you're okay, I do have questions floating in. I'll take the next set of questions here. Welcome back. Naeem Munisa, should my wife renew her H4 EAD based on my new I-797 validity, which is March 2025, the H1B, even though the current EAD obtained through my previous employer, valid until May 2025, has a longer validity?
Hmm. So I would not, first of all, there's no need to file a H4 every time, for your spouse to file a H4 or H4 EAD every time you are filing the H1. She continues to be on H4 status as long as you're maintaining your status and her I-94 is still valid. So in this situation, you really should not. There's no need to do it. In some situations, I would have said, go ahead and do it, even though you don't need to if the validity period is less. So you say her H4 was expiring in 6 months, then it would have made sense to do it because then both cases will get processed at the same time. When if she does it 6 months later on her own, then that could take several months to get approved. While doing it with you, the processing time is much faster. So in this scenario, I would say since you have a long validity period, there's no need to file an extension of the H4 along with the spouse's H1.
So I still remember, uh, almost 3 years ago during the pandemic, I guess, you answered the same question. Someone had changed jobs 4 times, and every time, although there was a 3-year approval, they were paying the fee, and every time they were extending, spending almost a whopping $2,000 or $3,000 just in the USCIS fee to extend the H4 along with the principal H1B. So she answered it. If you don't have to, you don't have to. I hope that answers your question. Let me jump into. Thank you, Prashanthi, for the
Welcome.
straightforward answer. It's easier, so you don't have to. That's the answer, right? Let me jump into my next question here from YouTube. Um, on the I-539 form from Subramaniam on YouTube, on the I-539 form for H4 change of status, when requesting an extension along with the H1B petition, how to fill the date field for status extension if the exact H1B expiry date is unknown? Can it be? I think the comment is cut off. Let me see if I have a follow up. Subramania, if you can, please comment with the remainder of this. I'm sure you did. You're from YouTube. Just let me take a look at the YouTube here. Uh, Okay. No, that's the question I have here on YouTube as well.
I
So,
think we have enough information, Dan, to respond.
okay, sure.
Um, so there is no reason why you would not know the expiry date of the H1, because when you're filing the I-129 petition, you're putting a start date and you're putting an end date on the I-129 form. So have that employer share the form with you, and the end date on the I-129 form would be the end date on your I-539 form, with reference to when until when you're extending your H4.
Okay. I think Subramanya, I hope your question is answered. We don't have, much time left now, so I'll quickly jump into the remainder questions here. Once again, Sirisha Reddy, while my H1B employer files a perm, can I switch to H4 and secure H4 EAD to work for them before the I-140 approval? So she's on an H1B, and the H1B employer is going to file a perm, but she wants to switch to H4 and get an H4 EAD. Are there any concerns or issues during the I-140 process due to my prior H1B status if I change to H4? What happens to the I-140?
Nothing happens to it; it continues as is. The Even if you are not on H4 EAD and not able to work for your employer, it would still continue as a future employment. The only issue would be that the ability to pay would might become an issue, because they will not be able to show that they're presently paying you that amount, so they'd have to show that as profits in the tax return. But in your situation, you're actually working for them on H4 EAD. You're not working on H1, but that doesn't make a difference for the ability to pay. They can still show your W-2 and get that I-140 approved. And so I don't see an issue with switching to H4 EAD in this situation.
Okay. Thanks for answering that question. Let me jump into the next one here. This is from Ahmad. My wife is currently on an OPT. We'd like to get her converted to H4 and wants to get H4, excuse me, get H4 EAD. Can anyone suggest me the process and how long does it take for that process? I think this is kind of a duplicate question, but if you can really touch this, I think he's been waiting there. Um,
How long does the process take? A few months, 4 to 5 months, sometimes 6 to 8 months. Um, it's usually faster if you file it with your H1, but if you file it separately, it's not as bad as it used to be. It used to be 12, 13, 14 months for H4 EAD. Now it's much faster. It's about 4 to 6 months now, which is still a long time, but faster than it used to be.
okay. Thanks for answering that question. I'll jump straight into, without any breaks, I'll jump straight into my next question here. Sam Dilton, I have an EB2 I-140 approved, and can I use the same priority date for the EB1? As there is no PERM nor PWD requirements for EB1, then how do we port the priority date? Kindly advise.
The priority date for EB1 will be ported at the time of filing the I-140. So when you're filing the I-140, you will submit the previous I-140 approval, and you will ask for the priority date to be ported, and it's just you put it in a letter request. There is no form as such to do that.
Okay, Sam, I hope your question is answered. So there is nothing about the PERM or PWD. It's just the at the time of filing your 140. That's the answer from the attorney. Thanks for answering that question. I'll take one more here before we end this session today. Um, I do have Milan Patel again. I don't get your comment. My wire. I'm not sure. I'm not taking that. But then I do have. I'm just looking at. If I skipped any comments here. It's a little clumsy, my interface. Okay. I have a question that I have my H1B cap exempt approved. However, my I-797 is only valid for 1 year instead of 3 years, I think. Is that normal or the employer will renew it every year?
You nowadays they're approving H1Bs for 3 years. They're not approving them for one a shorter period than that, unless the employer has requested on the I-129 form that it be approved for only 1 year. So you have to contact your employer to find out.
Okay. Before we conclude the session, there is going to be an H1B modernization program. And now we were talking about the renewal, visa renewals in the country. And then there is a long wait for the green cards, for especially Indian, Chinese, and Mexican and Philippine nationals. Are there any? I wouldn't say golden. Are there any ungolden words? Before we end this session for today.
Well, we are looking now at Biden's executive order on artificial intelligence and trying to see if there's anything that will come out of that. It's everything is in riddles. There's nothing that's written clearly. We have to wait for USCIS to give further clarity to the guidelines in the form of regulation. But they are talking about a couple of points, updating standards for O1, EB1s, EB2s, um, so that it's faster to get a green card based on that. I don't know how they will do it, but they're looking into it. Another important thing and a more practical way to do this is updating the Schedule A list. This is important. Right now, if you are part of the Schedule A list, like if you're nurses, physical therapists, etc., people who are where it's known to be a shortage area, where it's accepted by DOL that there are not enough people in the labor market to meet the demand. Those are Schedule A jobs. So if you belong to a Schedule A job, you don't have to file the labor cert. You don't have to test the labor market. So you can file an I-140 directly. And then, of course, you qualify based on EB2 or EB3. So it's still interesting if they include AI or IT professionals somehow related to AI into this list. Then of course that will be almost everyone. So I don't know how they will demarcate it. But I mean, all those details aside, if they include AI people into this list, then they don't have to go through the labor cert program. So that will save them right now at least a year and a half to 2 years. It'll shave the time off the processing time for them, and they can file an I-140 directly. So that kind of helps. They also talk about H1B modernization efforts. Now, this is a double-edged sword because when they refer to the H1B modernization effort, that is part of the proposed regulation, and there are a lot of bad things in there and some good things as well. So we have to see whether that really helps or actually hurts AI workers. So we'll have to wait and see how that pans out. And also, they're considering new regulations to enhance the process for AI experts to and their families to adjust status. So they're talking about 485s here, and I don't know how they are going to expedite 485 processing or visa number availability, green card number availability for AI. So that's something again they're looking into.
But the elections are upcoming, so there's a change in the party and the president. You know, again, we don't want to
Yeah,
be.
then this executive order is out the window because it's only an executive order. Unless the executive order actually leads to regulation, then it's kind of hard to change immigration regulation. You have to go through a process again and to reverse it, and most um, parties or governments don't want to do that. But we never know. Depending on the new government that comes in, yeah, anything is possible.
So, for our audience, where can they look up the Schedule A occupations if one of them qualifies? Maybe they're a nurse, maybe they are, as you said, AI. We expect AI to be included. We don't know, but then there's probably an existing Schedule A. Where can this be found on the Department of Labor website or just
You should
Google?
just go to Google and type in Schedule A occupations for immigration. something like that. Just Google it. It's available on Google.
Okay. Um, I still have, one last question from, actually two. Uh, no, just one. From Milan Patel, um, the hospitality person. If my wife is on a TN visa as a hotel manager, can her employer able to file a green card under EB3 in the future?
Yeah, absolutely. Anyone can file a green card. Um, only thing is you have to be in status. You can file the labor, and when you're filing the I-140, you have to show status. So yes, anyone can.
So, he's talking about the TN visa. So I'm assuming now he's from Canada, and if he meant for himself, yes. But then what happens to the immigrant intent on a TN visa when they initiate a green card? Will they
So
be able to get
though
another?
there is, yeah, though the TN is not a dual intent for the purposes of filing a labor cert or filing adjustment of status, that is allowed. There shouldn't be an issue. It's a partial dual intent non-immigrant visa. It's not like an F1 or a B1, B2 visa.
Okay. Um, we will end this, pretty soon. But then Subramania is back here. I think the question is, can I leave it blank on the 539? Where he was trying to, if he doesn't have it, most likely, and
No,
maybe.
you shouldn't. You shouldn't. No, you can't leave it blank. You have to put in a number there. If you don't have it because the employer didn't share it with you, I'm not sure why you wouldn't have it. But if you don't fill it out, then your petition will get denied because they don't know until when to give you the approval.
So they can just based on their records of the H1B records and.
No, they're not going to do that. They're going to do it based on what you ask. It's something that you ask them.
Okay.
Of course, they cannot give it beyond the H1B period, but within that period, uh, depending on how long you're asking for, you will get the benefit. If you don't ask for a benefit, you don't get it.
So it's likely that the employer has not shared a copy of the approval notice, so he's trying to file the
Well,
H1B.
you can guess and do it for 3 years, but if it is beyond the 3 years, then you might get an RFE, in which case, then USCIS might ask you to change it and they might allow you to do so. So you can try it going that way potentially.
I think Prashanthi, I'm sorry to interrupt you there. This is more case specific, not a general discussion on this show. So Subramania, if you need assistance with this matter, I think you should seek a consultation with Prashanthi. She can be reached at 212-354-1010, and or email her at prashanthi@readyesq.com, because this looks a little more private matter in terms of not having copies. Having said that, I think we would, we've had an overwhelming response today. But starting next week, we are going to be airing live at 2 p.m. Eastern Time instead of 12 p.m. Today was an exception, but then we will continue. We'll come with new topics and immigration updates, and definitely take all your questions. And please be prepared if you um, have any questions in the meantime. You have my email right up there, dan@higheritpeople.com. You can also send me an email. I'll definitely collect all these questions. And our upcoming session, you don't have to uh, comment. If I have a list of questions, we'll keep them ready for you and have a definitive answer from the attorney. We work together much before the show. I send her the questions. She does take time, although it's an Ask Me Anything um, session today. But then do subscribe to our YouTube channel, Immigration Talk Show, to get those updates. Many of the questions that you have asked today, they were already answered. So we have tons of videos that we uploaded, smaller videos with straightforward question and answer, and expert answers. Of course, we'll try to give you the best as possible. And thank you, Attorney Prashanthi. If there's nothing left for today, we should close this session. Thank you,
Thank
and
you, Dan. Thank you, everyone, for watching, and hope to see you next week.
thank you.